Okay, if you want to make a contract saying that someone is not allowed to get married, can you make that kind of contract? Can you enter into a contract which forbids someone from getting married? No, yes. If it is forbidden under Section 27 of the Contracts Act. Under Section 27, an agreement in restraint of marriage is void. So you cannot make a contract saying that someone cannot get married. Okay, so an agreement without consideration is also void. If you want to make a contract with another person, yes, if you want to make a contract with another person, they need to be some kind of consideration. The consideration does not need to be adequate. You can have a contract selling something under the market price. For example, if that thing actually costs 100 ringgit, but you only want to sell it for 10 ringgit, no problem, as long as there is consideration. So an agreement without consideration is void unless it falls under the exceptions. There are three exceptions under Section 26. And if you want to make a contract stating that if I breach the contract, you are not allowed to sue me in court. Can you make that kind of contract? Even if I breach our contract, you are not allowed to go to the court. Can you make that kind of contract? No. Yes, you cannot make that kind of contract because it falls under Section 29. An agreement in restraint of legal proceedings is void. So you cannot forbid someone from going to court if they want to sue you, but you can put some kind of clause inside there saying that if anything happen, we have to go to mediation first, or we have to go to arbitration first, or we have to negotiate first. You can put that kind of words in your contract, but you cannot say that anything happen, even if I breach the contract, you cannot go to court. You cannot say that because it is against Section 29. Okay, so that is a void contract. What happened to a void contract? What happened to a contract if it is discovered that the contract is a void contract? What are the remedies available to parties who are in a void contract? You have the right of restitution. Yes. So if a contract is found to be void, or if a contract becomes a void contract, you have the right to restitution. So the right to restitution means that any person who have received any advantage under the agreement is bound to restore it to the other party or pay adequate compensation. So you have to either return what you have received to the other party, or if you cannot return it, you have to pay compensation in lieu of restoration. So that is what happens when a contract becomes a void contract. Okay, a void contract. So, how can you discharge a contract? There are how many ways to discharge a contract? How to put an end to a contract? Four ways. How? What are the four ways? By frustration, for performance, and by breach. And Shakila, you're also right. There is another way, which is by agreement. But by agreement, I didn't put it in law of contract 3. I think I already put it in previous topics. But there are three ways under law of contract 3, but there are actually four ways. So the three ways are by frustration, by performance, and by breach. So a contract can be discharged in three ways: by frustration, by performance, or by breach. So what does it mean by a contract which is discharged by frustration? So what does it mean when you say that a contract is discharged by frustration? What does it mean by when someone said that the contract is frustrated? When a contract is illegal, it is void. But when a contract is discharged by frustration, in what kind of situation can a contract be discharged by frustration? When there is a change in the circumstances and the promisor could not prevent it. Yes. So when there is a change in the circumstances, when something happened, and that thing that happened is something which is beyond the control of the parties. So it is beyond the control of both parties. Both parties has nothing to do with it. It is beyond their control. They could not prevent it. So if something happened and that changed the circumstances of the contract can become frustrated. So usually a contract is frustrated when the contract becomes impossible or unlawful to perform. Usually a contract will be discharged by frustration. One of the ways for a contract to be discharged by frustration is when there is a war. Okay, so when there is a break of war and it is impossible for you to go from one country to another country, in that situation, a contract can also be discharged by frustration. Or in situation, for example, you want to perform in a musical hall, but what happened is the musical hall was caught on fire. So the musical hall burned down and you no longer have a musical hall. In that situation, a contract is also frustrated because it is something that happens beyond the control of both parties. Both parties have no way, they cannot prevent what happened. So that is when a contract becomes frustrated. Or in a situation where a contract becomes illegal. So in a situation where maybe that thing before this it is something allowed, but suddenly law changes and said it no longer allowed under the law. So in that situation, a contract can also becomes frustrated. Okay, so that is one of the way to discharge a contract. So what happened when a contract is frustrated? What are the remedies available to parties where the contract is a frustrated contract? So what are the remedies available for a frustrated contract? If a contract is frustrated, the parties also have the right to restitution. So when a contract is frustrated, it discharges the contract immediately, and whatever the parties, whatever advantages the parties has received under the contract, they have to return it. It is the same like section, like what happened if a contract is found to be a void contract. Okay, but you can only mm, you can only claim for remedies for what happened after the contract is frustrated. If you have any obligation before the contract is frustrated, it must still be fulfilled. Okay, so if something, like in the case of, I can't remember, but there is this one case. Yeah, in the case of Koldefa Construction, in that case, one of they are building a tunnel for railway company, and then what happened is the neighboring people around that area make a complaint because it caused excessive noise. There are too much noise when they are doing the construction, so they filed an injunction. So when they filed the injunction, the court held that they cannot do work according to the schedule. So according to the original schedule, they are going to do work day and night, and they are going to do it 7 days a week. But the court made the decision saying that you cannot work on Sunday, and you can only work for 2 shifts only. You cannot work late at night. So in that situation, the contract has also becomes frustrated. So whatever the obligation before the injunction happened, they still have to fulfill. But if anything happened after the injunction has been allowed by the court, they cannot claim because it already become a frustrated contract. Okay, so that is when a contract becomes frustrated. The last way, how to discharge a contract by performance? How can you make sure that you have properly performed your contract? How to make sure that the contract is properly performed? Does anyone know how to make sure that the contract is properly performed? How to discharge a contract by performance? For example, you made a contract with someone else, a contract to sell something. So you want to sell your car to another person. So how to make sure that you have discharged your contract properly by performance? You must have an agreement. Okay, so you must have an agreement, and if you want to discharge the contract by performance, you must make sure that you have performed you have performed the contract exactly as what is stated inside the agreement. So for example, if the agreement state that you are selling your car for 40,000 ringgit. So the seller must give the car to the buyer. The buyer must give 40,000 ringgit to the seller. And if the agreement also state that the name on the car must be changed to the buyer's name before the 40,000 is transferred. So the seller must also make sure that the name on the car is already transferred to the buyer's name before the 40,000 is transferred. So you have to follow the agreement exactly. So the performance of a contract must be exact, precise, and in accordance with what the parties had promised. So whatever you had agreed inside your contract, you must make sure that it is performed exactly like what you had agreed upon. Okay, so that is how to discharge a contract by performance. So what happened if, for example, you are selling something to another person and you have performed the contract exactly like what the other person has agreed upon, but the other party does not want to accept your goods. For example, you are selling something, and when you send it to them, they don't want to accept it. They don't want to accept it, and they don't want to pay for it. Does the contract is in that situation, is the contract discharged by performance? Okay, so the situation is like this. A sells to B. Kenapa tak keluar? Something is wrong. So for example, A sell goods to B, and he already make sure that what he is selling is exactly like they had promised. Baru keluar. But when he delivered it, but when he refused to accept. That situation, the contract is charged by performance. A sells good to B, A delivers the good, but when A deliver the goods, B refused to accept. So in this situation, is the contract discharged by performance? What do you think? Hmm, who is in breach? So in this situation, is there any breach? If there is any breach, by who? By A or by B? Yes, we are going to learn it today. But yes, in this situation, there will be a breach by B. But the contract is already discharged by performance of A. So it is under Section 39 of the Contracts Act. So if someone sells something to you and they had done their part of the contract properly, so you have done it exactly like what is in the contract, but the other party refused to accept it. The contract is judged by performance by you, by the person who sell it, A, but the other person who refused to accept it, there will be a breach of contract by the other party. Okay, so in this situation, attempted, we call it attempted performance. By A and refusal of B to accept breach. So in this situation, the contract is discharged by attempted performance by A because A had tried to perform the contract, but B refused to accept. It will amount to a breach of contract. So for today's class, we will see in this kind of situation what will happen. What are the rights of seller? What are the rights of buyer? Okay, so that is when a contract is discharged by performance. So if a contract is discharged by breach, that is when one of the party fails to do what they are supposed to do under the contract. So discharge by breach is the easiest one. And then next, we will look last one before we start our topic for today. What are the remedies available under the law for contract? How many remedies are there under the law? So there are 5 ways. What are they? Yes. So it is rescission, restitution, damages, specific performance, and injunction. So restitution, we have looked at it before. So it is for something that you have to return what you have received, all the benefits you have received under the contract. That is for restitution. Rescission is in only allowed under two situations: if a contract is breached or if a contract is voidable. Voidable is when the contract is entered without free consent. So when a contract is rescinded, the contract is cancelled. So when the contract is cancelled, uh, it is the parties are put to the original position before the contract was made. So the purpose of rescission is to um, put the both parties to the situation as if the contract has never been made. So that is the purpose of rescission. So what happen when a contract is rescinded? They don't need to perform your part of the contract, and if you have received any benefit, you have to return the benefit. So that is rescission. And then restitution, damages is the simplest one and the most common one. So in most situations, parties will be allowed to claim for damages. So damages is not to punish the wrongdoer, but only to put the injured party back in the position that they will have occupied if the contract has been performed. So if the contract has not been breached, what are parties supposed to receive? So that is the purpose of damages, to give the party what they deserve if the contract has not been breached. And then that is damages. Other than that, we also have two other types of remedies, which are specific performance. Specific performance is an order by the court where someone is compelled to carry out the obligation under the law. It is only in situations where damages is not enough. So if monetary compensation is not enough, there might be situation where the court can order specific performance. And then last one is injunction. Okay, so that is what we learn under topic 6. So for law of agency, we will see on law of agency in our tutorial class this evening. Okay, so for today's class, we are going to look into a new topic. It's a new topic, but it is actually related to the law of a contract. Today, we are going to look into one act which is called sale of goods, property and goods. The law of sale of goods, sorry. Yeah, SOGA 1957. The topic is wrong. Okay, so for today, we are going to look into one act, which is sale of goods. Sorry, there's a slight mistake in the topic title. So it is actually the law of sale of goods, not the law of sale and goods. Okay, so this is what we are going to learn today, which is the Sale of Goods Act 1957. So what we are going to look into inside this topic is first, we are going to look into what is SOGA. And then we also will be looking into what is considered as goods. Terms, right, under SOGA. And then we also will be looking at how transfer of ownership. So when the ownership of a goods transfer from the seller to the buyer. And last one, we are also going to look into what are the right of seller and buyer. So these are the 5 things that we are going to look into under this topic, which are, first we will be looking at the introduction. What is SOGA? Where is it applicable? Does it applicable throughout the whole Malaysia, or is it only applicable in certain states only? What is a good? Apa itu barang? What is considered as goods under SOGA? And then the terms of a contract under SOGA. Transfer of ownership, when the ownership of goods transfer from the buyer from the seller to the buyer. And last one, we'll be looking at the rights of a seller and rights of a buyer. Okay, so as an introduction, so the Sale of Goods Act 1957 is one of the 2 statutes which are related to consumer purchases. Actually, in Malaysia, we now have 3 acts which are related to consumer purchases. The first one is SOGA. The first one is the Contracts Act, Acta Contracts Act 1950. The second one is the Sale of Goods Act 1957. And there is actually another law for consumer protection, which is called Consumer Protection Act 1999. There are actually 3 acts related to consumer purchases. So these 3 acts works together. So if you are doing a transaction on goods, you have to refer to all 3 acts, because Sales of Goods Act will give some kind of protection. Contracts Act will give some kind of protection, and Consumer Protection Act 1999 will also give some different kind of protection to the consumer. Okay, so in Malaysia, our Sales of Goods Act 1957 is based on the English Sale of Goods Act 1893. So this Sale of Goods Act is a very old act. It is based on an even older act, which is the English Sale of Goods Act 1893. But it only applies to the states in Peninsular Malaysia. So if you look into section 1, subsection 2 of SOGA, SOGA only applies to the states in Peninsular Malaysia only. So it is only applicable to Perlis, Kedah, Perak, KL, Selangor, Johor, Melaka, Negeri Sembilan, all the states in Peninsular Malaysia except Sabah and Sarawak. So the Sale of Goods Act 1957 is not applicable in Sabah and Sarawak. So for some reason, Sabah and Sarawak still applied the English Sale of Goods Act 1893. So that act is later revised and replaced by Sale of Goods Act 1979. So in Malaysia, we have different acts governing consumer purchases in Peninsula and in Sabah Sarawak. So in Peninsula Malaysia, Sale of Goods Act 1957 is applicable. But if you are a buyer or a seller in Sabah and Sarawak, the English Sale of Goods Act 1893 will be applicable. Okay, so under Section 3 of SOGA, it states that the provisions of the Contracts Act 1950 continues to apply to contracts for the sale of goods unless they are inconsistent with the express provisions in the SOGA. So, under the law, if the provisions, if the sections in SOGA and the Contracts Act is the same, it can be applicable. But if it is inconsistent with SOGA, the SOGA will prevail. So if you have a contract and there is a different sections under Contracts Act, so maybe under Contract Act, you are the rights given are apa dah? So if the rights given under the Contracts Act is different from the rights given under SOGA, you have to use the provisions in SOGA. When you are doing, if the subject matter is goods, barang. So later we will look into what is considered as goods. Okay, so for if it is a goods which falls under the SOGA and there is a different provisions for it under Contracts Act, you have to use what is in SOGA. Okay, so what is the main purpose of SOGA? Is to offer protection to consumers in a sale of goods contract. Okay, so when you are in a sale and purchase agreement for goods, for barang, the SOGA Act will be applicable. Okay, so under Section 2 of SOGA, goods means every kind of movable property other than actionable claims and money, and includes stocks and shares, growing crops, grass, and things attached to or forming part of the land, which are agreed to be severed before sale or under the contract of sale. So basically, most things are considered as goods except these three things. So if you have land or things attached to the land, land is not considered as goods. So if you want to make a sale and purchase agreement on land, you have to refer to a different act. You cannot refer to SOGA Act because SOGA does not applicable to land. But if you have timber, kayu balak on the land, or you have crops, you have rubber trees, or you have palm trees, ada pokok kelapa sawit ataupun pokok getah dekat atas tanah tu, it is still considered as goods. Okay, but the land itself is not considered as goods. And then the second one, if you have a right under the law, for example, someone owe you some money, or you have patented a product, that is also not considered as goods. So if there is a breach of contract or anything, under the law, you can claim, but you cannot claim under SOGA. You have to claim under a different act, similar to land. If there is some problem in a transaction of land, maybe someone lied to you, or maybe there is a fraud transaction or anything, you can claim, but you cannot claim under SOGA. You have to claim under a different act. And then the third one is if it is a type of services. For example, you are a worker or you come to repair something, that is also not considered as goods. But other things, especially in a normal sale and purchase agreement, if you go to shop to buy something, or if you go to the market and buy something, all of that are considered as goods. So when it is considered as goods, you can use all the provisions under SOGA to protect your rights as a consumer. Okay, so up until here, do you have any question? Okay, so if you don't have any question about what is not considered as goods, next we will see on the classifications of goods. So all these terms, existing goods, future goods, ascertain goods, unascertain goods, specific goods, all this you can find it inside the SOGA Act. And you have to know the differences between all these classifications because we are going to be using all these classifications throughout our slides. Okay, so there are several set classifications of goods when it comes to SOGA Act. The first one is um, goods can be classified as existing goods and future goods. Okay, so when a good is considered as existing goods means that goods which are already owned or possessed by the seller. So in simple meaning, when that good is already stocked, you know kan, in the situation where you want to sell something, if that product is ready stock, when it is something which is already owned or possessed by the seller, it is an existing goods. But if the goods is to be manufactured or produced or acquired by the seller after the making of the contract of sale, it is future goods. Okay, so in simple online shopping terms, it is a ready stock, we call it. If it is what we call it in Shopee, apa?
Pre-order.
Pre-order, yes. If it is pre-order, we call it future goods. Okay, so if something is ready stock, it is an existing goods. But if it is something which is you have to pre-order, it becomes future goods. And then there is also a difference between ascertain goods and unascertain goods. So unascertain goods is when, for example, in a situation where you want to buy a car. Okay, so if you want to buy a car and you have not seen the car yet, you want to buy a car and you only know the car by description. For example, you read the brochure, and then when after you read the brochure, you tell the seller that you want to buy you tell the seller that you want to buy BMW new model 2021. For example, you tell the seller, I want to buy a BMW new model 2021. Okay, so in that situation, the product that you want to buy from the seller is an unascertain good because the goods it is only identified by description only and are not identified when the contract is made because the product has not been made yet, but you have already ordered it, so it is an unascertain good because you only said that I want to buy a BMW new model 2021 and you have seen the description of the BMW new model on the brochure. So in that situation, it is an unascertain good. But once the BMW have arrived in Malaysia and they have already identified that one of these BMW will become yours. So in that situation, the goods become an ascertain goods. Okay, so when you make a contract for unascertain goods for something that you have not seen yet, once the goods have become identified by the parties, you already know which one of the BMW is yours. It becomes an ascertain goods. Okay. So there is also another term for goods which is called specific goods. So specific goods is when the goods is identified and agreed upon at the time a contract of sale is made. Okay, so when you already know which car is going to be yours, which of the goods is yours, and you already identify that goods, it's become a specific goods. So the example is this. Ali agrees to buy Mahmud's car bearing registration number WPP888. For example, you are buying a second-hand car from your friend. You already see the car. You know which car you are going to buy. In that situation, your contract with your friend is a contract for the sale of existing specific goods. It is an existing goods because it is already owned by your friend, and it is a specific goods because you already know which car you are going to buy. In a different situation, Raymond order a new metallic grey BMW M8 Coupe, and the dealer already has a number of that make, model, and color in stock. So it becomes an existing unascertained goods. So when you order something where they already have the stock of that, but you don't know yet which one of it is yours, it is existing because the car is already there. The car is ready stock, so it is existing, but it is still unascertained goods because you don't know which of the car is yours. But once that car is selected and identified to you, so when you already know which of the car is yours, it becomes existing ascertained goods. But if the dealer is selling a new BMW car which is yet to be made, the car is a future unascertained goods. Okay, so to make it simple, it's like this. It is, okay, I already told you if it is ready stock, it is existing. If it is already identified, you know which one is yours, it become if it yet to know out of the 10 cars which one is yours, it is unascertained goods. Okay, so if it is something ready stock, it is existing. If it is pre-order, it is future. So ascertained and specific goods can also be used interchangeably. But when it is already identified, it is ascertained. If it is not identified yet, it is unascertained. Okay, but if you order something which has not been made yet, it will become a future unascertained goods. Because one, it is not made yet, so it is a future goods. It is a pre-order, so it is a future goods. And another one, you also don't know which one will be yours. So it is unascertained goods. I think I have one situation. Okay, I give you one situation. If you are if you want to buy a new car, if you want to buy a second-hand car, so you already know which car is it. You already know the registration number for that car, but the car is still still belongs to the original owner. It will become a future ascertained goods. So if you are buying a second-hand car, you already know, is it? But the car still belongs buying a second car from it will become a future okay, so there is five terms: ascertain, unascertain, specific, existing, and future goods. But actually, specific goods is similar to ascertain goods. It's only that ascertain goods is for a contract where the goods in the first place it is unascertain and it becomes ascertain goods. That is only the difference. But actually, ascertain goods and specific goods is similar. When you already identified it and you know which one is yours, it becomes an ascertain goods. So it also becomes a specific goods. Yeah, specific and ascertain is actually similar to each other. You can also say that this is a future specific ascertain goods, and you also can call it a future ascertain goods. Okay, so that is the terms for classification of goods. Okay, so why must we know the difference between existing goods and future goods and the difference between ascertain goods and unascertain goods? Is because of this. Okay, so we look at this first. Because under this under SOGA, we have two different type of agreements. The first one is a contract of sale. Another one is agreement to sell. Okay, so a contract is a sale. A sale is a contract under which the property in goods means the ownership. So whenever I use the word property in goods, I am actually referring to ownership of the goods. Because the words property in goods is used in SOGA, but it actually means ownership of the goods. So when there is a contract under which the ownership is transferred from the seller to the buyer, it is a contract of sale. But when you have a contract under which the transfer of the property in the goods in which the ownership of the goods will be transferred at a future time or subject to some conditions being fulfilled, it is an agreement to sell. So we have two different type of agreement. So when it is a goods which is ascertain, existing, when a goods is an existing ascertain goods, the contract is a sale of goods contract. So if it is a so if it is a sale for a specific or ascertain existing. Okay, so if it is a specific or ascertain existing goods, it is a contract of sale. But if it is a future un goods of ascertain goods, it is agreement to sell. Okay, so if it is a specific ascertain specific or ascertain existing goods, it is a contract of sale. So if the property is if the goods is ready stock goods and you can deliver it at any time, it is a contract of sale. But if it is something which is it have some kind of conditions that you have to be fulfilled, or if the contract is going to take place at a future time, you already signed the contract now, but the car is only going to be given to you next month, it is an agreement to sell. Okay, so an agreement to sell becomes a sale when the time elapses, or the conditions are fulfilled. So why must we differentiate between sale and agreement to sell? Is because if it is a sale, there are different remedies given to you under the law. But if it is only an agreement to sell, you will get different type of remedies under the law. That's why we have to differentiate between what is considered as sale and what is considered as an agreement to sell. Okay, so if you under a contract of sale, section 4 stated that a contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods. They agree to transfer the ownership to the buyer, the ownership of the goods to the buyer for a price. So that is when you enter a contract of sale of goods. So a sale occurs when the ownership of property in goods passes to the buyer. So for a contract of sale to come into existing, you must fulfill 4 elements. So there are 4 elements of a valid contract of sale of goods. So if you want to sell something, or if you want to buy something, you have to fulfill all these 4 elements. First, there must be parties to the contract. So both the seller and the buyer must fulfill all the capacity as required under Contracts Act 1950. So under Contracts Act, it states that only a person who is of age of majority, who is not a minor, and a person who is not of unsound mind, it must be a sound person, only those people can enter into a contract. So a minor cannot enter into a contract except for contracts in certain situation, and an unsound mind person cannot enter into a contract. So both the seller and the buyer must fulfill all the capacity as stated under Contracts Act 1950. So if you want to sell something, or if you want to buy something, first, there must be parties to the contract. Second, there must be a transfer of property. So there must not only be transfer of possession, but there must also be transfer of ownership. In normal goods, it may not be clear, but for example, if you are selling a car, or if you are selling something which is your ownership is stated in a grant or something. For example, if you want to sell a car to your friend, or if you want to sell a motorcycle to your friend, the motorcycle will come with a grant. So the grant will state the name of the owner. So when you want to sell a car to another person, you must not only give the car to your friend, but you must also change the name on the grant. So there must not only be transfer of possession, but there must also be transfer of ownership. The owner of the goods must change. So that is the second element. And then the third element is there must be a price as consideration of the contract. So the contract must be the price. The contract must have some kind of consideration. And what type of consideration? There are 3 types of consideration for a sale of goods contract. First one, the price may be fixed by the contract. So if there is a written contract and the price is stated in the contract, the price can be fixed by the contract. Or the price may also be left to be fixed in a manner agreed. For example, a third party can fix the price, or another way is it can only be determined by the course of dealing between the parties. So the price can be, the consideration is the price, but the price can be fixed in many different types of ways. if you want to make an agreement, for example, an agreement where um, you are buying something, for example, you are buying something at the price of 500 ringgit. Okay, so you are buying something at the price of 500 ringgit, and the product will be delivered to you in 3 months' time. Okay, so the product will be delivered to you in 3 months' time. The product is sold at the price of 500 ringgit, and you are allowed to pay for the product in installment. So you can pay up to 3 times. So you can pay maybe 200, 200, 100, or maybe 250, 150, 50. But you can pay up to 3 months. That is also considered as a price under the contract. So that is what is considered. So that is what we mean by the third one. It may be determined in the course of dealing between the parties. So the parties can fix the price, one lump sum, or they can allow a third party to fix the price, or they can also put different ways to pay for the product. They want to do it in installments, or they want to do it, you can take the product first and pay later, in whatever way, as long as there is a price, there is a consideration of a contract, it is a valid contract. And then the last one, the subject matter must be within the definition of goods under SOGA. Okay, so for a contract of sale of goods, you must fulfill all these 4 elements. Okay, elements in a contract of sale of goods. This one I also covered. Okay, so before we move on to the terms of the contract, do you have any question?
No, madam.
No question. Okay, so if you don't have any question, we will continue with the terms of the contract. Okay, so in a sales of goods, as it is a commercial transaction, actually a common law maxim, caveat emptor, there is this one common law maxim states that let the buyer beware is generally applicable. So actually, when you are buying something or when you are selling something, the common law maxim is where the buyer must check the product themselves is applicable. So it means that where it is possible to discover by inspection the quality and conditions of the goods, the buyer will generally lose any legal rights against the seller if the goods are not satisfactory. So this especially comes into play when you are buying something face to face. So when you already look at the product, you already check the product, you already inspect the product, you already know the quality of the product, you already know the conditions of the product, but you still buy the product even if maybe you have already checked the quality, and then after that you buy the product, you will lose any legal rights against the seller if the goods are not satisfactory, because you already inspect the product, you already check the product. Okay, so the buyers only have themselves to blame if they fail to make a careful inspection of the goods before they purchase them. So under the law, it clearly states that if you want to buy something, especially when you are buying from a shop, yeah. So when you are buying from the shop, you have the chance to look at the product. You have the chance to feel the product, to know the quality of the product. After that, if you buy it, you cannot return it. So that like what your friend said, some of the shops will put this label stating that goods sold are not refundable. So you only have yourself to blame if you fail to make a careful inspection of the goods before you purchase them. However, especially now, when we are having all this online transaction, you can only buy something. You can buy something only scrolling on Shopee or scrolling on Lazada. You can buy things online, and you don't have the chance to look at the product. You don't have the chance to feel the product. In that situation, many of the terms inside the SOGA will be applicable. So in certain circumstances, the common law rule will be unjust where there is no reasonable opportunity for inspection, or when the buyer has to rely on the special knowledge or expert judgment of the seller. So for example, when you are buying something online, in that situation, SOGA will be applicable. 3 days to return if the goods are not satisfied. On that, I think we will look into it later. We will look into it later on this thing. On that thing, if it is something is given warranty, for example, the seller state that you have 7 days to return if the product is not satisfactory. You have to follow that. If you can return it within 3 days, the seller will still be responsible. But after the lapse of the 3 days, if you still did not return the product, if anything happened after that, you are considered to have agreed to the so you cannot do anything after that. We will look into it later, Sakila. Okay, so under the general rule, if you already see the product, you cannot return it. But there is in certain situation, like I said before, if you buy something online, you have no reasonable opportunity for inspection. Or if you buy something which is pre-order, if you pre-ordered something, and for example, when you are buying a car, when they give you the car, you don't know whether the car is in good condition or not. So because you have no opportunity to inspect the car. So in this kind of situation, SOGA will be applicable. Or in the situation where you buy something and you don't know anything about the product. You have to rely on the special knowledge of the seller because you don't know anything about that product. You have to rely when the seller tells you that this is good, this is working. So you rely on what the seller says. In that situation, you are also protected under SOGA. What about durian fruits, Hadi? What's wrong with durian? Cannot see inside in that kind of situation. In that kind of situation, we will look into this. I think it will fall under one of this. Fit for intended purposes. I think it will fall under either these two terms. Fit for intended purposes or merchantable quality. We will look into it later. Okay, so in certain kind of situation, you can still claim under SOGA. So SOGA implies a number of terms into the contract as either conditions or warranties. So just like under the Contracts Act 1950, there are certain terms which is a condition and there are certain terms which is a warranty. So just like under the normal Contract Act, if the term is a condition, it is a term essential to the main purpose of the contract. So if it is breached, it gives right to treat the contract as repudiated. So when we look at these implied terms, some of this will be an implied condition and some of this will be an implied warranty. So if it is an implied condition and it is breached, you can return the product. But if it is only an implied warranty, it is not a condition, you cannot return the product, but you can claim for damages. Okay, so warranty is a term collateral to the main purpose of the contract. It gives right to claim for damages, but not a right to reject the goods. Okay, so we will see under these implied terms, in what kind of situation you can return the product, and in what kind of situation you cannot return the product, but you can claim for damages. Okay, so what happen if there is a stipulation about time in the contract? So in a contract of sale, time of payment is not considered to be of the essence of the contract unless specifically stated otherwise. So under the law, if a buyer fails to pay by an agreed date, it does not entitle the seller to cancel the contract. So under the law, if you order something and they deliver it to you late, or if you are buying something and you already got the product but you pay for it late, it is not an essence of the contract. So it is only considered a breach of warranty. So you cannot cancel the contract. You can only claim for damages. That is when it comes to time. Okay, so this is the main crux of the topic. Implied terms. So when you are buying items from the shop, or when you are buying something online, usually you will not sign any contract. So usually when you are going to the shop to buy something, you will not sign any contract with the seller. You will not have any written contract with the seller. So that's why under SOGA, there are 1, 2, 3, 4, 5, 6, 7. There are 7 implied terms that can be read into a contract of sale between you and the seller. Into a contract of sale. So when you are entering into a contract of sale, even if you have nothing written, you don't sign any agreement, all these implied terms will be applicable. So what are these implied terms? The first one is implied condition as to title. So the owner of the product is an implied condition. So there is an implied condition that the seller has the right to sell the goods in the case of a sale, or in the case of an agreement to sell, the seller will have the right to sell the goods when the time comes for the buyer to become the owner. Okay, so the first one is title, the ownership. Who is the owner of the goods? Who is the owner of the product? So it is an implied condition. So when you want to sell something, you must make sure that you have the right to sell that product. So usually someone will have the right to sell the product. For the first one is, if you want to sell, you have to make sure that the owner of the product, or you have the authority Okay, so this is the first one, implied condition as to title. So if you are a seller, if you want to sell a product, you have to make sure that either you are the owner of the product, it does even if the product is in your possession, but if you are not the owner of the product, you still don't have the right to sell the product. You must have the ownership of the product, not only the possession of the product. So under the law, possession is when the product is with you. Ownership is the product is yours. Okay, so when you want to sell a product, the first implied terms is title. The product must be yours. Okay, if the product is not yours, you cannot sell the product. Okay, if you sell a product which is not yours, it will become a breach of an implied condition, and it will entitle the buyer to cancel the contract and recover the price in full, even though he has used the goods. So, for example, your friend is living in London, and your friend asks you to take care of his car. Okay, so for example, you have a friend. That friend moved to London, and that friend said that because I'm not going to use this car while in London, you can use my car, but you cannot sell the car. So you can so I allow you to use my car. So the car will be in your possession. But even if the car is in your possession, you still don't have the right to sell the car. Okay? Because you are not the owner of the car. Unless you get the authority from your friend said that I'm not going to return to Malaysia anymore, you can sell my car. In that situation, you have the authority to sell the car, then you can sell the car. But unless you get the authority from your friend to sell the car, even if the car is with you, the car is not yours. When the car is not yours, you cannot sell the car. Okay, because it is based on the rule of nemo dat quod non habet, which state that one cannot give what one does not have. So if you do not have the title to the product, you cannot give away that title. Okay, so for example, in this case of Roland against Deval, in this case, one of the parties, Roland, bought a car from Deval. And when he bought the car, he used it for 4 months. After 4 months, he discovered that the car is actually a stolen car. Kereta tu kereta curi. So when the car is a stolen car, Roland returned the car to the true owner. So the issue here is whether Roland can recover the full amount he had paid for from Deval. So he buy it from Deval. So after he had returned the car to the true owner, he asked for the full amount that he had paid from Deval. So the issue is whether he can claim the full amount because he already used the car for 4 months. But in this case, the court held that although Roland had used the car for some time, he was still entitled to recover the full price he had paid because Deval actually has no right to sell the car because Deval is not the owner of the car. So in this situation, as Roland has failed to get the title of the car, there was a failure of consideration. So even if you had used the item for some time, you can still claim the full price because this is a breach of condition where the seller does not have a good title. Okay, so this is the first implied term. If you want to sell a product, you must have a good title on it. You must be the owner of the product or you must have the authority to sell. If you do not have the authority, it will become a breach of condition. And when it becomes a breach of condition, the buyer can cancel the contract and the buyer can claim the full price that he had paid from you. That is the first implied term. Any question on the first implied term? Is it clear on the first implied term? Okay.
Yes, ma'am.
Okay, so that is the first implied term. If you want to sell something, you must have the title. You must have a good title. You must be the owner of the product. And then the second implied term. The second is not a condition. It is only a warranty. So in this kind of situation, you cannot cancel the contract, but you can claim for damages. So the second implied term is implied warranty that the buyer shall have and enjoy quiet possession of the goods. Okay, so it is an implied warranty that the buyer shall have and enjoy quiet or undisturbed possession of the goods. So it is a warranty that once you buy something, you should be able to use the product, to use the goods whenever you want, wherever you want, at any time that you want. So that is the second implied term. When you already buy something, someone else should not claim possession on that product. The product should be yours. You should be able to use it wherever you want, whenever you want, at any time that you want. Okay, so this second term is a warranty to protect the buyer from unnecessary claim by any third party or the seller himself after the sale has taken place. Okay, so if you have the title, it is to so this second implied term is to protect you from any claim by the third party. So in this situation, yeah, it also means that we will look at it later, but it also means that once you have buy a product and once you have once you have bought the product, apa nak cakap tadi? Lupa dah. Yeah.
Utility claim.
So once you have bought the product, any third party cannot put any claim on the product. For example, even if you buy a product which is given not under a good title. For example, the seller is actually tak apalah, kejap lagi lah later. It is actually related to something later in the topic. But I'll just talk about it later lah. Okay, so this is an implied warranty. You can somebody else, anyone else, nobody else can disturb your quiet possession of the goods. So if your this term is breached, if someone have put a claim to the product or the seller still use the product after he has sell the product to you, you are entitled to claim for damages. Okay, so for example, in this situation, Kasim sold his car to his friend Ali, and because Kasim liked the car very much, he often persuaded Ali to lend him the car. So Kasim had a set of the car key and he used her car whenever he likes, regardless of whether Ali allows it or not. So this is a breach of an implied warranty that Ali should have and enjoy quiet possession of the car. Yeah, like what your friend said. You cannot buruk siku. You cannot take back what you have given to somebody else. If you take back what you have given to somebody else, it will be a breach of implied warranty and your friend can sue you for damages. Okay, so that is the second implied term. The third implied term, implied warranty, this is also a warranty, implied warranty that the goods are unencumbered. Okay, so under section 14, subsection C of SOGA, it is an implied warranty that the goods must be free from any charge in favor of a third party who is unknown to the buyer. So if you want to sell something to someone else, unless you tell that person that these goods are encumbered, you have to pay something for this good, the goods are supposed to be unencumbered. So for example, if you want to sell something and you want to sell a car and there is a pending summons on the car, you have to settle all the summons before you can sell the car, because it is a warranty that the goods must be unencumbered. Or if the car have any kind of charge that you have to settle before you sell the car, you have to settle all the charge first before you can send the goods to the buyer, unless the buyer knows about it and he agrees to pay for it. There is this one term under the law. I'm not sure whether you have heard of this term. Have you heard of it? As is where is basis. not sure whether you have heard of this term or not, as is where is basis. But if you buy a product which is under an as is where is basis, if there is any encumbrance on the product, you cannot claim under this implied warranty.
Miss, like, can I have another example for this because I don't understand.
As is where is means that as is where is okay. It means by as is where is. As is where is when the seller is selling and the buyer is buying an item in whatever condition it presently exists, and the buyer is accepting the item with all faults. So when you are buying something in normal condition, in normal situation, when you buy something, the goods must be unencumbered. It means that the good must be, there must not be any problem. The goods must free from any charge. But if you are buying something as is where is, in that situation, when, for example, when you buying, I'm not sure about it, but I think it's applicable. For example, when you are buying a car during auction. Okay, so usually goods sold during auction is sold at as is where is basis now. So when you are buying a car during auction, so after you bought the car, discover that so you bought a car during auction. After you bought the car, you discover that the car already have 10 summons. In this situation, you have to settle the 10 summons. Because goods bought so the implied warranty okay. Yeah, in normal situation, if in normal situation you buy a car and you discover that there are summons under the car, you can claim for damages because it is actually in normal situation, it is a breach of implied warranty. Okay, so in normal situation, it is a breach of implied warranty. Goods are there are encumbrances on the goods. Okay, so in normal situation, if you buy a car from someone else and you discover that there are summons under the car, you can claim for damages on the car from the owner. But if you buy a car during auction, a car is sold on as is where is basis. So when it is sold on as is where is basis, after you buy the car, you discover that the car already have summons. In that situation, you cannot use this implied warranty because it is bought on as is where is basis. So as is where is basis is this one. So when you buy something under as is where is basis, it means that you agree that you buy that car in its present condition, whatever the condition is. Or if you in your contract you state that you agree to pay for whatever charges for the car, in that situation you also have to pay. But in normal situation, in general situation, if you did not sign anything, you did not sign any agreement saying that if there is any charge, I will pay for it, or you did not buy the product under as is where is basis, you can claim under implied warranty. Okay, so like in this case of Stink against Edward, in this case, what happened is what happened in this case of Stink against Edward is this car is sold multiple times. So in this case, the original owner is A. A sold the car to B. B sold the car to C. And C sold the car to D. Okay, so this is the case of Stink against Edward. In this case of the original owner is A. A sold the car to B. B sold the car to C. C sold the car to D. So D so D found out that the car road tax has not been paid yet. So D discovered that A actually never pay road tax for the car. So when a car is not when the road tax of a car is not paid, the car will be forfeited. So once the car was forfeited, D had to pay the road tax to the government to get the car back. And in this situation, the court held that there is a breach of implied warranty because the car is supposed to be free from encumbrances. So in this case, court held that D can claim for road tax from C. C can claim the amount from B, and B can claim okay, so the court held it like this. The court said that because it is a breach of implied warranty, D can claim for road tax from C, C can claim from B, and B can claim from A. Okay, so when you are buying something, unless you buy it on as is where is basis or you agree to pay for any encumbrances on the product, there is an implied warranty that the goods must be unencumbered. So if there is any encumbrances on the product, there is any encumbrances on the goods and you have to pay for the encumbrances, you can claim for it from the original seller. Okay, so that is the third implied warranty. Yes. As at here, do you have any question? You have any question on any of the three implied terms? Title, quiet possession of goods, unencumbered goods?
No, madam.
No.
Good.
Okay. So if you have you have any question, we continue to the fourth one. The fourth one is an implied condition. So the fourth one is an implied condition that in a sale of goods by description, the goods must correspond with the description. Okay, so when you are buying something and the things is described, for example, when you are buying something from a brochure, or you are buying something from a catalog, or you are buying something from an advertisement, there is an implied condition that the goods must correspond with the description. So what is described about the goods must be the same as the goods. So it is an implied condition that the goods shall correspond with the description. Okay, so when you buy something, if you buy it by reference to a sample as well as description, it must correspond with both the sample and the description. So in this kind of situation, but if you see in the fast food ads, usually it will put there, I'm not sure if you realize it or not, it will put that that yeah, usually if you looking at an advertisement, usually they will put this for illustration purpose only. So what is the purpose of using putting that words is actually to protect them against this one. To protect them against this implied condition. Because if not, they can be sued for breach of condition. So that's why usually they will put for illustration purpose only. Gambar sekadar hiasan sahaja. Okay, so when you are buying goods, by reference to a sample as well as description, you must correspond with both the sample and description. So for example, you want to buy, for example, you are a reseller of coat. For example, you are a reseller of coats, and you want to buy a coat from the supplier and then sell the coat to someone else. So when you visit the original supplier, the supplier will show you the sample. The supplier will show you one sample. Okay, this is the clothes. This is the coat that we are going to make for you. So you can look at this coat. If you agree, we can make 100 coats with the similar quality of this one. Okay, so that is what we call a sample. So they give you one coat for you to check, for you to inspect, and then you order 100 coats of the same description. So if the goods are sold by reference to a sample as well as description, it must correspond with both the sample and description. So you must, so as a seller, you must make sure that the product that you have supplied to the buyer, it must be the same quality as the sample that you had shown, and it must follow the description that you have put on the product. Okay, and it covers all cases where the buyer has not seen the goods but is relying on the description alone. So if you are buying something relying on the description only, for example, when you are buying on Shopee or on Lazada, you are only relying on description, this implied condition is applicable. Okay, so in this case of, you can see the example in this case of Nagurdas Purushamtundas ne. In this case, both parties actually have a previous contract. Okay, so this is actually a contract for the sale of flour, tepung. So under the previous contracts between the parties for the sale of flour, the flour had been sold in bags bearing a well-known trademark. So previously, they already have a contract between the parties, a contract to buy flour. So before this, the flour was sold in a different package. And then after the first stock of the flour has finished, the buyer wants to buy a second stock. So they order further flour, they order more flour from the supplier. And it states in the contract that we want flour the same as our previous contract. So the second stock, the flour is given in identical quality, but it did not bear the same well-known trademark. So the product is similar, but it is not put in the same the packaging is different. Okay, so in this situation, the court held that the goods did not comply with the description. Okay, so so it means that if you are buying something from someone, you must if you are selling something to someone, you must make sure that the description and the actual product must be similar in quality. It must the actual product must fulfill all the description. Okay, so it also covers sale of unascertain goods and sale of specific goods from catalog or mail order. And there is this one case which states that even though the buyer has seen the goods, he still can claim if it does not correspond to the description given. So the case given here is the case of Bill and Taylor. So in this case of Bill and Taylor, the seller advertised his car as Herald convertible, white, year 1961. So he put it on advertisement saying that he is selling a car, a Herald convertible car, white color, made in 1961. Okay, so before the purchaser bought the car, he already made an inspection. He already inspect the car before he buy the car. So after inspecting the car, he agrees to buy the car. But after purchasing the car, he only after that he realized that the car was actually not the model as advertised. So it was not actually a 1961 model. Only the back portion was 1961 model, but the front portion was an older model. So in this case, the court held that even though the purchaser has made inspection, the seller still breached the implied terms on the description because the purchaser relied on the description when making the decision to purchase. So the purchaser still had rights to terminate the contract and to claim damages. So in this case, this case is the authority to use if to say that even though the buyer has seen the goods, he still can claim if it does not correspond to the description given. Wait, I want to go back to your friend's question. Okay, like the question from Shakila about things that you give 3 days to return if the goods are if you are not satisfied with the goods. I don't know. This is for different. That is for different part of question. Okay, so in this situation, it states that even if you have seen the goods, you still can claim if it does not correspond to the description given. So if the description is different and what you have produced, what you have, the actual product is different, it is a breach of implied condition. So when it is a breach of implied condition, you can cancel the contract and get full refund. Okay, so that is the berapa tadi? The fourth implied terms. Okay, so that is the fourth implied condition. And then the fifth one is there is also an implied condition that the goods must be reasonably fit for the purpose for which the buyer wants them. Okay, so when you buy a goods, a buyer must exercise care when he make purchases. So if he does not, he must bear the consequences. Okay, so as a general rule, if you want to buy something, you have to check the product first. You must inspect the product first. But if you did not check the product, you must bear the consequences. So in normal situation, there is no implied warranty or condition as to the quality or fitness of goods supplied under a contract of sale except in 3 situations. So in normal situation, what you buy is what you get. But if you falls under these 3 exceptions, you can still claim under a breach of implied condition. So the 3 situations are: the buyer told the seller why the goods are required, or the buyer relies on the seller's skills or judgment, or the goods are of a description which is in the course of the seller's business to supply. Okay, so if your case falls under any of the 3 above situations, it can be said that there is an implied condition that the goods must be fit for such purpose. Okay, so in normal situation, what you buy is what you get. But if you already tell the seller, I want to buy this for this, so the seller must make sure that the goods is reasonably fit for the purpose for which the buyers want them. Or for example, you when you go to the shop and buy a charcoal, usually why you want to buy a charcoal? What is the purpose of buying
Barbecue.
charcoal? For what?
Barbecue.
For barbecue, yes. For example, you want to do a barbecue dinner. So you go to shop and you buy charcoal. So a charcoal is supposed to be reasonably fit for burning. Okay, and then something happened. The charcoal is but when you buy the charcoal, something is wrong with the charcoal. For example, the charcoal actually the um, the charcoal actually contain the charcoal is somehow contaminated. For example lah, in this situation, the charcoal is somehow contaminated, and when the charcoal was contaminated, what happened is if the charcoal was put into fire, it will explode. Kalau you letak charcoal tu dalam api, dia akan meletup. Okay, so in that kind of situation, we can say that there is a breach of implied condition. Because when you buy a charcoal, you want to put it in the fire because you want to make barbecue. But if the charcoal cannot be put into fire without getting exploded, without it being exploded, so in that situation, the charcoal is not fit for the purpose for which the buyer wants them. Okay, so in that situation, there is a breach of implied condition. Okay, so when you buy a charcoal, to be able, you are supposed to for burning. Charcoal without exploding. So in this case, there is a breach of like condition because the charcoal is not fit for the purpose for which the buyer wants them, or in a situation where the buyer relies on the seller's skills or judgment. For example, you go to the pharmacy and then you tell the person at the pharmacy that I want to buy a product for my acne. I want to buy a product because my face is full of acne. I want to buy a product that can heal that. So when you go to the pharmacy sells you a cream. And you rely on the seller's skill or judgment, you use the cream. But actually the cream is not for acne. Actually the cream is for fungus, for example. The cream is for fungus infection, not for acne. So in that kind of situation, that it is also a breach of condition. Because when you buy a cream for acne, the cream is supposed to be, you are supposed to be able to use the cream on your face. But when the seller sells you something which is not fit for the purpose, the fungus cream actually is not supposed to be used on the face, and you use it on the face, there will be a breach of condition because you rely on the seller's skill or judgment. Because you don't know which cream is good for you. You rely on their recommendation, and then they give you a wrong recommendation. So in that kind of situation, there is a breach of implied condition. Or if the goods are of a description which is in the course of the seller's business to supply. So the seller is actually a seller who supply that kind of thing. So when you buy it, you believe that it is fit for the purpose, but actually it does not fit the purpose. In that situation, there is also a breach of implied condition. Okay, so if you buy a product under its patent or other trade name, there is no implied condition as to its fitness for any particular purpose. So for example, when you go to the shop and buy Colgate, you buy toothpaste under the brand name of Colgate, or you go to the shop and you buy instant noodle under the name of Maggie. So in that situation, um, because you are buying it under a patent or other trade name, there is no implied condition as to its fitness for any particular purpose. So when you go to the shop and buy Maggie, or you go to the shop and buy Colgate, if something wrong with the product that you use, you cannot claim it from the seller, because in that situation there is no implied condition that the goods must be reasonably fit for the purpose for which you buy them. Or if you buy the goods for a special purpose, the purpose must be made clear to the seller. Or if you are suffering from any peculiarities, or if you have a sensitive skin, or if you are allergic to something, you have to tell them to the seller. If you does not tell that you are allergic to something to the seller, you cannot claim if anything happened to you because you failed to tell that you are allergic to something to the seller. That is what happened in the case of Griffiths against Peter Conway. In that case, one woman, she has unusually sensitive skin. So she is allergic to many things. So she go to the shop and she bought a tweed coat, one coat, without disclosing that facts to the seller. So even though this woman know that she has sensitive skin, she has allergic, she buy a coat without telling the seller that she is allergic to that thing. So she contracted dermatitis from wearing the coat. In this case, the court held that the claim could not succeed under this section, as the coat would not harm a normal person. The plaintiff failed to disclose that she suffered from skin problems. That's why she cannot claim. So similarly, if you have any kind of allergy, or if you are suffering from any peculiarities, which is does not happen to normal people, you have to tell the seller about that thing. If you did not tell the seller about that thing, and and the seller sell the product to you, you cannot claim for breach of implied condition. Okay, so this is similar to the situation where when you buy a shoe, we do know that some shoes have this some shoes is made from pig skin. Okay, so we do know that in certain situation, pig skin is used to make leather product. Okay, so when you go to the shop to buy something, you have to tell the seller that I don't want to buy anything made from pig skin. Because if you do not tell the seller that you don't want to buy anything made from pig skin, and the seller sells to you something which is made from pig skin, you cannot claim for a breach of condition. But if you already tell the seller that I don't want to buy anything made from pig skin, and the seller still sell to you something which is made from pig skin, there in that situation there will be a breach of implied condition. So you can return the product and you can get full refund. But in the situation where you did not tell the seller about the pig skin and they sell the pig skin to you, you cannot return the product and claim for full refund. Okay, and then if you want to use this one, the buyer relies on the seller's skill or judgment. The buyer must show that there is some reliance on the judgment and skill of the seller. So you must tell the seller clearly that you are relying on his judgment and skills. Like what happened in the case of Camel Laird and Co. In that case, there was a contract by one party to buy to build something for another party in accordance with the buyer's specifications. So the buyer already specified the design and it already specify that it need to be used on which type of ship, which type of engine. But because the buyer does not know about the thickness of the blade, so this is actually a contract to build a blade which is a propeller for a ship. So the buyer already tell that I want to use it on this ship and I want to use it on this engine. But because the buyer does not know how thick the blade should be, so the buyer does not specify on the thickness of the blade. So the buyer states that the details as to thickness of the blades are left to the seller's skill and judgment. So in this situation, the seller supply the product, but the product does not suit the ship engine because the thickness is wrong. So in this situation, the court held that the seller was liable for breach of an implied condition because the buyer has informed the seller that he wants to use it on a particular ship and he relied on the seller's skill to provide them. Okay, so if you rely on someone's skill, you have to tell them that you are relying on them. If not, you cannot claim. Okay, so that is for the 1, 2, 3, 4, 5. So that is for the 5th implied terms. Okay, 5th and then 6, 2 more. The 6th implied term is there is also an implied condition that the goods must be of merchantable quality. Okay, so under the law, where goods are bought by description from a seller who deals in such good, there is an implied condition that the goods shall be of merchantable quality. So the product must be a product suitable for selling. So it shall be of merchantable quality. So the exception is if the buyer has examined the goods, the implied condition is no longer applicable, though the examination is superficial. So if you already checked the product, you cannot claim that the product is not of merchantable quality. So what does it mean by merchantable quality? It refers to the goods state or condition. The condition of the goods. The goods must be reasonable for the purpose described. If the goods can be used for several purposes, the goods will be merchantable if it fit one of the purposes. So, for example, if someone tells you that this product can be used to clean the toilet, you can use it to clean the toilet, and you can also use it to mop the floor. For example, they say that it can be used to clean the toilet. It can also be used to mop the floor. And when you buy it, it can be used to clean the toilet, but it does not work when you use it to mop the floor. It causes some kind of damage if you use it to mop the floor. In this situation, because it fits one of the purposes, because it can be used on the toilet, the goods is still merchantable. So that is what happened in the case of Henry Kendall. In that case, there is this one seller. He sells Brazilian groundnut extract. So he is selling some kind of extract, and he sells it to the manufacturers of cattle and poultry foods. Okay, so when he sells it to the manufacturers of cattle and poultry food, the manufacturer use it to make meals for cattle and poultry. So one of the buyer, they buy the meal and they lost a large number of young poultry. So it was discovered that the extract is actually poisonous. So the extract actually is suitable for cattle and is suitable for older poultry, but it cannot be used for young poultry. Okay, so in this kind of situation, they use it for so in this situation, the extract actually can be used for cattle and for older poultry, but it cannot be used for younger poultry. But in this situation, the court held that as the extract was suitable for some purpose, it is suitable for cattle, it is suitable for older poultry, there was no breach of implied condition of merchantable quality. So the product is still merchantable. It's only that it cannot be used, it actually cannot be used for young poultry. So there is no breach of implied condition. How about if the buyer did not check the amount of 1 ton of durian? You buy 1 ton, and when the durian arrives, some of the durian were rotten. Sekejap Okay, I think for your question, it might fall under this last implied terms. Okay.
All right.
Okay, so I finish this one first. Okay, so if the product is advertised that it can be used for several purposes, but it can only be used for one purpose, even if if does not fit some of the other purposes, if it can fit one of the purposes, it is still be merchantable. But if the goods can only be used for one purpose, but if they were of no use for that purpose, it becomes unmerchantable. Like what happened in the case of Rand and Holt. In that case, the Mr. Rand went into a hotel and asked for a beer, but the beer actually was contaminated because there is some problem lah. So the beer somehow it become arsenic. So Rand, after drinking the beer, he fell ill. So in this case, the court held that because a beer is only made for drinking, only for one purpose, you only sell beer because you want people to drink it. But because the beer was not drinkable, someone cannot drink it without falling ill, the beer become not of merchantable quality. It become unmerchantable quality. So in that situation, there is a breach of implied condition. Okay, so if the product can only be used for one purpose, but it cannot be used for even for that purpose, it becomes unmerchantable. But if it can be used for several purposes and it can only be used for some of the purposes, it is still a merchantable quality. Okay, so that is for the sixth one. And the last one, if you buy something by sample, if a contract of sale is a contract by sample, there is a three implied conditions. So the bulk shall correspond with the sample in quality. The buyer shall have reasonable opportunity of comparing the bulk with the sample. The goods shall be free from any defect, rendering them unmerchantable, which would not be apparent on reasonable examination of the sample. Okay, so in this kind of situation, you, for example, someone is selling you a sample. For example, you want to buy durians. Okay, you want to buy a bucket of durians, and the seller will not let you taste all the durians in the bucket. They will only give you one sample to check. Okay, so when someone is selling you something by sample, the seller must make sure that the bulk corresponds with the sample in quality. So when you want to sell something to someone and the sample you give them is Musang King durian, you must make sure that all the other durians in the bucket is also a Musang King type of durian. Okay, so when it so the bulk must have the same quality like the sample. But if the differences are minor and the quality is the same, so for example, maybe the durian that the sample that they give you is the newer durian, the ones which was harvested yesterday, and the one in the bucket is the durians which are harvested maybe 3 days ago. The condition is still not breached. Okay, but the buyer must also have reasonable opportunity to compare the bulk with the sample. So you must look at the bulk and you have to compare with the sample. So in the situation where you buy 1 ton of, you buy a big sample of food, and when the food, some of it were rotten, can you claim for damages? Wait, I look at the wait Yeah, because your question is related to perishable goods. Let me see. For your question, because it refers to perishable goods, I'll check back on it first and I'll inform you later on that. Because I think all the examples given in the book are referring to not for perishable goods, because this is perishable goods. So in normal situation, if it is not a perishable goods, if you are referring to product, if you sell by sample, the bulk shall correspond with sample in quality. So what you get must be similar in quality to the sample, and you must have the opportunity to compare what you receive and the sample, and the good shall be free from any defect. Okay, but if the quality is not the same but similar, or the difference is just a minor difference, the condition is still not breached. Okay, like in the case of Drummond. Okay, so in the case of Drummond, this is actually a manufacturing company. A manufacturing company who made cloths. So they submitted, so they promote their new material to cloth merchants. So when the cloth merchants has checked the sample, he agrees to buy the product, the new material. So an order was made for a quantity of material of a weight and quality equal to the sample. Okay, so when they received the material and they made it onto a garment, onto a cloth, they realized that actually when it is made into garments, there is some defects, because this material is actually not suitable to be made into garment, because it will split at the seams. So it is unsuitable for the purpose for which it was intended, even though the quality is actually equal to the sample. So in this case, the court held that even though the cloth was equal to the sample, it still does not protect the manufacturer where the defect could not have been discovered by a reasonable examination. So the purchaser was not bound to accept the material. So when you see something on a sample, for example, when you see a cloth on a sample, and then after that, when the cloth was used to make some kind of product, but after it was made into product, it becomes unsuitable. In that situation, you can still claim for breach of implied condition, because even if it is something that you cannot discover it when you just see the sample, compared to when you have see the finished product, you can still claim for breach of implied condition. Okay, like in the case of Drummond and Van Ingen. So in this case, even though the cloth is okay, but when it was made into product, it becomes unfit for the purpose. So in that case, you can still claim for breach of implied condition. Okay, so I think we can have a break for maybe 15 minutes. So after 15 minutes, we will continue with the balance of the slides. And for your question on the perishable goods, I'll check. So I'll give the answer either after break or during our tutorial in the evening. Okay, so 15 minutes break. Thank you.
Okay, madam.
Okay, madam.
평생 그러고 살았거든요.
Okay, hello.
Hi, ma'am.
Mm. Okay. So we will continue with the next subtopic, which is transfer of property and ownership. Hadi, your question actually falls under, when I Google it, it actually falls under different acts, which are Consumer Protection Act 1999 and the Food Act. So I have to do a bit more reading on that before I can answer that question. Yeah, it does not fall under SOGA when it comes to food. Okay. So we continue with the next subtopic, which is transfer of property and ownership. So in a sales of good, when does the property transfer, when does the ownership of the property transfer from the seller to the buyer? Okay, so as I already mentioned earlier during our earlier session, the passing of ownership in goods does not mean that possession also passes with it. So possession is when you have something with you, but ownership is when that things belongs to you. Okay, so even if you pass the possession of the goods, it doesn't mean that the ownership of the goods changes. Even if you pass the ownership of the goods, it doesn't mean that the possession pass along with it. Okay, so in sales of goods, it is important to know when a property in goods is passes to the buyer. So it is important to know when the ownership passes to the buyer, because it relates to who have to bear the risk on the goods. So if something happened to the goods, who have to pay for the loss? Okay, because risk of loss of goods goes with the person who has the ownership in the goods. Okay, so the owner of the goods have to bear the risk of loss of goods. So if something happens to the goods, the one who has to suffer the loss is the one who is the owner of the goods. Okay, so under Section 26 of Sales of Goods Act 1957, goods remain at the seller's risk until the property is transferred to the buyer. But when the property has been transferred to the buyer, the goods are at the buyer's risk whether delivery has been made or not. Okay, so as long as the goods remain with the seller, it is owned by the seller. The owner of the goods is the seller. But once the property is transferred to the buyer, once the ownership transferred, the goods will be at the buyer's risk. So it doesn't matter whether the property has been delivered to the buyer or not. Okay, so but there are exceptions that if delivery is delayed due to the fault of either party, the goods are at the risk of the party in fault. So if the property is delayed because of the fault of one of the parties, if anything happened, the party who caused the delay is the one who have to bear the risk. Okay, so ownership passes differently in different situations. Okay, so there are 1, 2, 3, 4, 5, 6, 7, 8. There are 8 ways to pass ownership of goods. Okay, so the general rule is the ownership of goods is transferred when the parties to the contract intends it to be. So if there is any contract, the ownership of the goods transferred when the parties agree for the ownership to transfer. So that is the general rule. But there are also 7 different situations which determine when does the ownership pass. Okay, so the first one is section 18. So the passing of ownership is laid down in section 18 until section 24 of the SOGA 1957. So section 18 is on sale of uncertain good. So for a sale of uncertain good, the ownership can only be transferred after the goods is ascertained. Okay, so as long as the goods is not identified yet, as long as the goods you still don't know which of the goods are yours, the risk is still with the seller. Once you have identify which one is yours, you already know which of the goods is yours, then the ownership of the goods will be transferred to the buyer. Okay, so that is under section 18. And then next, under section 19, if the goods is a specific ascertain goods, so if the goods is something which is already ready stock, and or it is something which you already know which one is yours, the ownership transfer at the time as agreed by the parties. So if the parties agreed that once payment is made, the ownership is transferred after payment is made. If the parties agreed that the ownership transferred after the transaction is confirmed, then the ownership is transferred after the transaction is confirmed. So it depends on the agreement between the parties. That is for something which is ready stock, something which you already know which one is yours. So next, under section 20, if it is a sale of a specific goods, a sale of something which you already know what is it, something which is ready stock, something which can be identified in a deliverable state. Okay, so if it is a sale of something which you can deliver it at any time, so it is already in a deliverable state, the ownership passes to the buyer when the contract is made. Okay, so for section 20, for example, Ben agree to buy Joe's bicycle, and Joe agree that Ben will pay him next month. Okay, so both parties already agree to buy and sell the bicycle. So in this case, because it is a sale of specific good in a deliverable state, because the goods is already identified, you already know what you are selling, you already know what you are buying, and the goods is ready to be delivered, the ownership passes when the contract is made. Okay, so it does not matter that the bicycle have not been delivered yet, and it does not matter that the other party have not paid for the bicycle yet, because it is something which is deliverable state, so it is something that you can deliver at any time. Okay, so the ownership passes when the contract is made. That is for under section 20. But where there is a contract for the sale of specific goods and the seller is bound to do something to the goods for the purpose of putting them into a deliverable state. Okay, so that is for under section 21. So under section 21, if the goods is the goods to be sell must be put in a deliverable state, meaning that you have to do something to the goods first before you can deliver this before you can deliver the goods. The ownership does not pass until the goods is in a deliverable state and the buyer is notified about it. So for example, if you agree to buy a car, for example, two people agree, for example, A agree to buy a car from B, but with the condition that B must repair the car and paint the car in a different color. For example, A wants to buy the car, but with condition that the car must be repaired first and the car must be painted in a different color. Okay, so in that situation, the car must be put in a deliverable state, meaning that the car, you must do something to the car before you can sell the car. So the ownership does not pass until B has repaired the car and B has painted the car. So once B has repaired and painted the car and B told A that I already repaired the car, I already paint the car in a different color, then after that the ownership passed to the buyer. That is for under section 21. Okay, for section 22, if you are selling something that need to be weighed, something that need to be measured, something that need to be tested, or something that you need to do something to that thing to ascertain to know what is the price of that thing, the ownership pass after the goods is weighed or measured and the buyer has notice of it. So this is, for example, when you go to the shop and you want to buy fruits. So and the fruits is sold at 5 ringgit per kilogram. Okay, so the fruit is sold at 5 ringgit per kilogram. So what you have to do is the seller must take the number of fruit that the buyer wants and put it on the weighing machine, and he must check how many kilo is the fruit, and then he has to tell the buyer how many kilo of it, how many kilo is it. Okay, so once the seller told the buyer, okay, I already measured the fruit and it is 2 kilo. So you have to pay 10 ringgit. So at that time, the ownership passed from the seller to the buyer. Okay, so that is under section 22. Okay, so once the seller tells the buyer the price that the buyer needs to pay for the fruit, at that time, the ownership has passed to the buyer. That is for section 22. And then under section 23, section 23 is for contract of sale of unascertained or future goods by description. Okay, so when you are buying something online, you are buying something online and that thing is a pre-order punya item. So it is pre-ordered item, not something which is ready stock, because it is future goods. You have to pre-order it and it is unascertained, meaning that you don't know which of the product will be yours. The goods will only the ownership of the goods will only be transferred to the buyer once the goods is posted. That is for under section 23. Okay, so under section 23, if you buy something pre-order online, the ownership of the item only transferred to you once the seller has posted out the item. So once the item is posted out, the ownership of the item will transfer to the buyer, and if anything happened to the item during delivery, the buyer have to bear the cost. Okay, and this one under section 24, sale of goods delivered to buyer on approval or sale or return. So this section 24 is for items like the question of Shakila, the item which states that if you don't want the item, you have to return it by within 3 days. So that falls under section 24. So under section 24, the sale of goods delivered to buyer on approval or sale or return, the ownership only passes to the buyer if he accept the goods or he did not expressly accept the goods but retain the goods until the time fixed to return the goods expires. So under section 24, if someone, if you buy something and it was stated by the shop that if you are not satisfied with the conditions of this product or if you don't want this product, you have to return it within 10 days. So if you does not return it within 10 days, the ownership will pass to the buyer at that time. Okay, so that is for under section 24. So once the due date for returning the item has expired, the item become yours, the ownership has passes to you, and you cannot return it back anymore. That is for section 24. Okay, so that is some of the rule. When does the ownership pass from the seller to the buyer? Do you have any question?
No, madam.
No question. Okay, so if there is no question, we'll continue with the next subtopic, which is what happens if a product is sold, an item or product, a goods is sold by a person who is not the owner of the goods. Okay, so under the law, as a general rule, when a buyer takes ownership of the goods, he or she only gets the same rights to the goods as the seller of the goods. So under the law, there is this one legal maxim which states that no one gives what they do not have. Okay, so under the law, it means that if a buyer bought some goods from a seller who is not the owner of the item, or the seller does not have any authority to sell the item, the buyer does not acquire any title even if he has paid the value in good faith. So that is expressly stated in section 27 of SOGA. It means that even if you had paid 10,000 ringgit to buy a motorcycle, but after that you found out that the motorcycle is actually a stolen motorcycle, at that time you still have to return the motorcycle because you do not have the ownership of the motorcycle, as the person who sell the motorcycle to you is not the owner of the motorcycle. So you have to return the motorcycle. The rightful owner of the goods is entitled to recover his or her goods from those who have no title to them. But you can claim for damages. That is for in the situation where you buy something from a person who is not the owner of the goods. But there are 6 exceptions to this rule, meaning that if your case falls under one of these 6 situations, even if you buy something from someone who is not the owner of the good, you still have a good title to that goods. So if your situation falls under any of these 6 exceptions, ownership of the title passes to you. But if your case does not fall under any of these 6 exceptions, even if you have paid money for it, you still cannot claim ownership of that property. Okay, so the first situation is the situation of estoppel. Estoppel arises when the owner of the goods is, by his conduct, precluded from denying the seller's authority to sell. So this is, for example, in the situation where someone, for example, a car belonging to a husband is sold to another person by his wife. He knows that his wife is trying to sell his car, but he doesn't say anything about it. He just let his wife uh, sell the car. After that, when someone wants to buy the car, he is precluded from denying the seller's authority to sell, even though he never tell his wife that you can, I give you the authority to sell my car. But because he does not deny when he knows that his wife is selling the car, he cannot after that tell the buyer that no, actually my wife doesn't have the title to that car. The car is actually mine. He is stopped from doing that. Okay, so if you know that someone is doing something without your authority, you have to make sure that you told that person clearly that he does not have the authority. If you did not tell the person that he does not have the authority, if a third party wants to buy the property, you are stopped from denying the right of the third party. Okay, so that is the first exception, estoppel. Okay, so the second exception is sale by mercantile agent. If you have an agent may pass a good title in selling goods belonging to his principal, provided that he is acting under the scope of his actual or apparent authority. So if someone is selling your property as your agent, if your goods is sold by your agent with the consent of the owner, in that situation, it can be said that the property is the ownership of the property transferred from the principal to the buyer if it is sold by your agent. However, if you want to be protected by in a sale from an agent, if you buy something from an agent, you have to make sure that you fulfill all these conditions before you can claim ownership on the item. The first one, you must make sure that the agent is in possession of the goods at the time of sale. So when you are buying the product, the goods must be with the agent. And then the agent is in possession of the item with the consent of the owner. So the owner know that the goods is with the agent, and the owner consent that the agent have the goods with him. And then the third condition is the sale must be made while acting in the ordinary course of business. So there must not be any fraudulent or any fraud or any forgery. There must not be any wrongful act. It must be a normal business transaction. And then the fourth condition is, as the buyer must act in good faith, and the buyer must have no notice of the agent's lack of authority. So in that situation, if you fulfill all these conditions, even if you buy it from an agent who does not have who is lacking authority from his principal, your title, you still have a good title, a good ownership of the goods. Okay, that is for the second one, if you buy it from an agent. The third one, if you buy the item from one of the joint owners. For example, if the product is owned by more than one person. So if the product was sold by one of the goods joint owner, it is valid even without the consent of the other owner. So even if the other owner does not give consent for the sale is still valid. So the condition is the seller must have the sole possession of the goods with the consent from the others, and the buyer must act in good faith and have no notice of the lack of authority. So for this sale by one of or joint owners ni, the example is like this. For example, there is this one rice cooker. For example, you have one rice cooker which was jointly owned by A, B, and C. So A, B, and C, they buy the rice cooker together. So they are the joint owners of the rice cooker. Okay, so even though the one who bought the rice cooker, there are three people who bought the rice cooker. They allow one of the person, maybe they allow B to keep the rice cooker because A and C does not know how to cook. So A and C does not know how to cook. So A and C said that B, you can keep the rice cooker, but whenever we want to eat rice, you have to provide for us lah. So in that situation, if B sold the rice cooker to a third party without A and C's permission, the sale is still valid. Okay, so that is for the sale by one of the joint owners. So the buyer of the rice cooker will still have a ownership over the rice cooker, even though the sale was without the consent of the other owners. Okay, so that is the third exceptions. The fourth exception is the sale under avoidable title. So for example, if someone obtain a property under coercion. Okay, so for example, B got a property from A, but the property was actually given under coercion. Okay, so A and B has an agreement. A transfer the property to B, but actually the property was given under coercion. Actually, A was forced to sign the contract with B. In that situation, if the contract has not been rescinded at the time of sale, the contract is still valid at the time of sale. A does not claim anything, does not claim to cancel the contract at that time. And B sold the property to a third party. The third party will get a good title. Okay, so even if the title is, even if the item was under avoidable title, I mean, even if the seller's title is not a good title, the buyer will still get a good title as long as he buys them in good faith and without notice of the seller's defect of title. So if he is a bona fide third party purchaser, even if anything happen, he will still get to good title of the property. And if A wants to claim anything, A can only claim for damages from B because it has nothing to do with C anymore. C bought the property in good faith. Okay, so that is for the fourth exception. And the fifth exception, if someone sell a product, someone sell a product A, sell a product to B, but B have not taken possession of the product yet, and then A sell the product to a third person, C. So A sell a product to B and without B's knowledge, because A is a bad person, A sell the product again to C. Okay, so in this situation, C have a good title for the product. So the ownership can still pass to C, provided that C is betul lah. So if A sells a product to B and B has not taken the possession of the product yet, and A sells the product again to C. So in that situation, C has a good title of the product, provided that C receive the goods in good faith. So provided that if C does not know anything about A's transaction with B, C will still have a good title to the product. So what B can do is B can only sue A for breach of contract. Okay, and then the last situation is sale by a buyer in possession. If a buyer having bought goods and then sell it again to a third party, it is all the third party buyer is also can also be he can still pass good title to a subsequent buyer. So sorry, for the last one, If a buyer, having bought or agreed to buy goods, obtain possession of the goods with the consent of the seller, he can pass good title to a subsequent buyer of good faith, even if he did not obtain good title under the first transaction. Okay, so for the last one, the example is so example is in the case of Newtons of Wembley Limited against William. In that case, the plaintiff sold a car to A who paid by check. Okay, so plaintiff sold the car to A who paid by check. Okay, so once A had paid the car by check, plaintiff had released the possession of the car. So the car is already with A. And then what happened is that A has resold the car to B. And after A has resold the car to B, the plaintiff found out that the check was dishonored. Check tu tendang. So actually he doesn't get any money from B. So B, even though he pay using check, but the check is actually a dishonored check. So B does not. So A does not get any money from the sale, and at the time the car has already been sold to a third party. So in this situation, the court held that the plaintiff cannot take back the car because even though B does not have a good title for the car, but because C has buy the car in good faith, A cannot get back the car. So the car is with C, and C has good title for the car. If A wants to claim anything, A have to claim it from B. It's similar as sale by a seller in possession after sale. If you are a victim in the transaction, you still cannot get the property from the third party because the third party has already take good title to the product, to the item. So you can only get your damage from the party who breached the contract. Similarly, in this situation, because the buyer has resold the car to another person, you cannot get back the car from the third party, but you can claim for breach of contract from the buyer itself because the buyer does not pay for the car. The check was dishonored. So that is the 5 situations where even if the seller does not have the title to the does not have the ownership of the goods, he still can pass good title to the third party. So only if it falls under these 6 situations can a third party get a good title. If it does not falls under any of these exceptions, if someone who sold you the car does not have any ownership of the car, even if you have paid money, you cannot get to good title for the property. Okay, so before we go to the last part of this topic, do you have any question? I know this topic is quite confusing because there are so many things. But it's okay. During the class this evening, we will try to look into some of the questions, how these terms can come into play. Okay, any question? No question. Okay, but if there is no question, we will go to the last subtopic, which are the rights of sellers and buyers. Okay, so there are 1, 2, 3, 4, 5, 6. So there are 6 rights of buyers and sellers under SOGA. So for seller who has sent the goods but did not get paid, there are some rights. So there are rights of unpaid seller against the goods. There is also rights to sue for breach of contract. There are also rights of the buyer to sue for damages for non-delivery. For example, if buyer has already paid for the item but the seller does not deliver the item, the buyer also have the right to sue. The buyer also have the right to bring an action for specific performance. For example, buyer has paid for something, but the seller refused to do his part of the contract. The buyer also have the right to bring an action for specific performance. In some situation, if there are breach of warranty, buyers also have the right to remedies. And then there is also some rights of buyers to take action under tort. Okay, so the first one. If you are a seller and the buyer does not pay for what you are selling to them, or the buyer pay for what you sold to them, but the negotiable instrument used by the buyer has been dishonored. An example of the case before, the buyer pay by check, but the check was dishonored. Check tu tendang. So what are the rights of unpaid sellers in this kind of situations? The first one, for a seller who was not paid for the goods that he has served, first he has the right to create lien. So lien is when you retain the goods. You did not deliver the goods. You retain the goods. So if the seller is in possession of the goods, he has the rights to retain the goods until payment is made. So if there is any conditions stating that you have to pay first before I deliver. So if the buyer does not pay, the seller has the right to retain the goods until payment is made. So that is the first right, to create lien. The second right is stoppage in transit. So in the case where the buyer becomes insolvent, the buyer becomes a bankrupt, or the seller has posted out the goods, but the buyer does not pay for it yet, the seller has the right of stopping them in transit as long as the goods are still in the course of transit. So in this situation, if a seller have any means to stop the item from being delivered, the seller can stop the item from being delivered. So what happened is it has the effect of restoring the right of possession to the seller. So you can either hold it in transit or you can ask them to return it to you. Okay, so that is the second right of an unpaid seller. If the buyer does not want to pay, he can stop the transit. He can stop the item from being delivered, or he can retain the item until the payment is made. However, if the product or the item has been sold to a bona fide third-party purchaser, so the buyer has already sold the product to a third party. In that situation, the third-party buyer is protected from the seller's right of lien or stoppage in transit. So if the item has already been sold to a third party, the seller cannot hold the item. He cannot retain the item and he cannot stop the item from being delivered because it was already sold to a third party. He can only claim for damage. So the third rights of a seller who was not paid for the goods that he has sold is he can resell. He can sell the product again to another person. However, a contract of sale is not rescinded by the mere exercise of an unpaid seller of his right to lien or stoppage in nature. So if you are a seller and the buyer refused to pay for the item, you have no right to sell the buyer's item unless it falls under these three situations. The first one, the goods are of a perishable nature. For example, you are a seller of food product, and the food product have an expiry date. The food product will expire in 6 months' time, for example. If the buyer refuse to pay for the product, you are allowed to resell the good to another person. because if you did not sell it to another person in 6 months time, it will not be you cannot sell it anymore, so you will suffer loss. So that's why you are allowed to resell the goods to another person. Or you have give the notice to the buyer that you want to sell the goods to another person, and the buyer does not within a reasonable time make payment for the goods. So for example, in the situation of someone has hired you to make her a clothes. For example, someone hired you to sew a dress for her, to make a dress for her. Okay, so you has made the dress, and then you tell the buyer that if you want the dress, you have to pay to me, and I will deliver the dress to you. But the buyer does not want to pay for the dress. So in this situation, you can tell the buyer that if you did not take your dress in 2 weeks time, I will sell it to another person. So if you have tell the buyer that in 2 weeks time, if he does not take the possession of the dress, you will sell it to someone else. And the buyer, after 2 weeks, the buyer is still silent. The buyer does not make payment for the goods. The buyer does not take her dress. You can sell it to another person. Or if in the contract, you clearly state that the seller expressly reserve a right of resale in case the buyer default in paying the price of the goods. So if you have any agreement with the buyer saying that if you did not pay for the good, I will sell it to someone else. In that situation, you can sell it to another person. So these are the 3 rights given to a seller whose buyer refused to pay for the goods. That is under section 46 of SOGA. The next one, right of seller to sue for breach of contract. This is under section 55 and section 56 of SOGA. The seller can sue for the price of goods if the ownership has passed to the buyer and the buyer wrongfully neglects or refuses to pay for the goods. So if you have already posted out the item and the item is already received by the buyer, but the buyer refused to pay, in that situation, you can sue for breach of contract. Or you have an agreement with the buyer saying that I will deliver the item to you in 3 months' time, but you have to make payment for it first. You have to make payment for it first 1 week before I deliver the item to you. Okay, so it is contracted that the price be paid on a certain date. Be paid on a certain date before delivery. So in this situation, if the buyer fail to pay at date as agreed upon, the seller can also sue for breach of contract, even though the item is still with him and the goods has not been delivered, because you agree that you have you will pay in 1 week before the delivery. So on that 1 week, if you haven't paid, the seller has the right to sue for breach of contract. Okay, or the third situation, the seller sell the item to a buyer, but the buyer refused to accept the item. So you already deliver the item to the buyer, but the buyer refused to accept and the buyer refused to pay for the goods. In that situation, the seller can sue for damages for non-acceptance. So if you refuse to accept, the seller can take back the item and he can sue for damages for non-acceptance. For example, if someone is buying a cake from you, you already deliver the cake, and then the buyer said that I don't want the cake anymore. He refused to accept the cake and he refused to pay for the goods. So you as a seller can sue for damages for non-acceptance. That is the right to sue under breach of contract. In a different situation, section 57, if a seller refuse to deliver items to the buyer already paid, but the seller refused to deliver the item, the buyer can bring an action for non-delivery. This is stated under section 57 of SOGA. Okay, so both if the seller already deliver buyer refuse to accept, seller can sue for non-acceptance. If buyer already paid, seller refuse to deliver, buyer can sue for damages for non-delivery. Or in some situation, if the goods are of special or peculiar kind, it is a valuable painting, or it is a priceless antique, or it is something which is unique. In that situation, buyer can also bring action for specific performance. So he can ask the court to make an order for the delivery of that goods to him. But it is only available at the discretion of the court. If the court believes that damages is enough, it can be compensation is enough for his trouble, the court will not allow for specific performance. But if damages is not enough, the buyer can also bring an action for specific performance. And then for breach of warranty, if there is a breach of warranty, as mentioned before, under implied terms, we also have 3 to 4 breach of warranty, which is considered an implied breach of warranty. If the seller commits a breach of warranty, the buyer cannot reject the goods, because if it is only a breach of warranty, you still have to accept the goods, but you can either sue for breach of warranty, or you can ask the seller to lower the price. For example, if you buy something which actually is supposed to be valued at 20 ringgit per item, but because of some mistakes by the seller, the item can only be sold at 10 ringgit per item. So you can ask the seller to pay you the difference between the original price and the price that you have sold the item for. So the seller will be liable to pay the differential sum of 10 ringgit, because there is a breach of warranty. Or the last one is a buyer can also sue the seller in tort. There is these 2 tort related to consumer, which is tort of detinue and tort of conversion. So detinue is wrongful detention of chattels, is movable items belonging to the plaintiff after their return has been demanded. So if the plaintiff has demand that you return a movable item to them and they refuse to give it to you, you can sue for tort of detinue. Or if someone has used the property which belongs to you, you can also sue for a tort of conversion. So that is all under the topic of SOGA. Okay, so all of these are under the topic of law of sales and goods. Do you have any question on any part of this topic?
All of the terms I say look alike, Miss.
Sorry?
All the terms look alike a bit. It's same.
Yeah, because all of it are actually inside the SOGA, and SOGA, I think they want to cover as many situations as possible. That's why they have all the similar terms inside it.
Okay.
No worries. For those who are inside my tutorial group, I will put maybe 4 to 5 questions so that we know how to use all these long terms inside the question. How is it going to be asked in exams? We will discuss about it during our tutorial class. Yeah, because there are so many conditions, I know. And the conditions are similar. This is your only law papers for the course, right? Or do you have any other law papers?
I think we have company law, if I'm not mistaken, Miss.
Are you allowed to bring any acts to the exam hall? Not sure.
We're not sure, Miss. as before when I'm studying my diploma, that time I had this subject, but that time they never allowed us to bring anything.
Okay. Because like this like this subject, I think if you can bring the acts, it might be easier for you. But if you cannot bring the act, there's so
But
much.
is it like they allow means in other universities? They allow, is it?
For law students, we are allowed to bring some acts.
Oh.
Yeah, that's why I asked. For law students, usually they allow us to bring, for example, if you are learning contract law, they allow you to bring contract act into the exam. Or maybe sometimes they provide the contract act. At least you don't have to remember all the sections. Yeah.
Hope ours also can. Ours is online.
Yeah, for this semester it's online. And for this topic, I think I only put one question on it because
Complicated.
yeah. But it's okay. For this evening's class, I try to draft maybe 3 to 4 questions so that we can know at least how to use some of these terms inside the question. How is it going to be asked in the exam questions? Okay, do you have any question? As at now?
No, miss.
Okay.
No, miss.
Yes.
Seems okay.
Okay, so maybe you can read it again before our evening class. Sorry, there are some I think there are some grammar mistakes. I will check the slides again and I will re-upload it on your UNIC. But only all the mistakes are just small ones. No worries. Okay, so if there is no question, that's all for today. Thank you. Don't forget to submit your reflective paper for those who are in my class. The submission date is today. If there is no other question, I'll see you during the evening session. Thank you.
Thank you,
Thank you,
miss.
Miss.
Thank you, madam.
Thank you, Miss.
Thank you, madam.
Thank you, Miss.
Thank you, miss.